Then let's start. Hello, everybody. My name is Maya Nieta. You can see me, but I'm here. I'm a postdoctoral researcher here at the Bonavero, and I'm very excited to be welcoming you to this brilliant event. We'll hear today from several fantastic speakers, all of them here in person. First, Dr. Naomi Lott, the organizer of this event, among her many achievements, is an ESRC postdoctoral research fellow at the Faculty of Law here at the University of Oxford, and an early career fellow at the Bonavero Institute of Human Rights. Her primary research interests are in the field of children's rights, with a particular focus on children's economic, social, and cultural rights, and on the notion of forgotten rights in general human rights law. Her new book on children's rights to play, based on her PhD written at the University of Nottingham, is forthcoming as a monograph in Routledge. And if you're interested in these topics, she has an impressive line of events coming this term. So follow the website for details of future events this term and in general. I'll introduce Pamela and we'll introduce the other speakers before their
Pamela and I are going to present together.
Yes. So Pamela Vargas Goena is a research fellow in human rights and anti-slavery law at the University of Nottingham. Her research focuses on mapping global anti-slavery legislation and policy in order to understand trends, successes, and failures, and identify factors contributing to positive legislative change. Her research background includes comparative law and jurisprudence, as well as the assessment of government law, policies, and capacities. She holds a Master's of Science in Public Policy from the University of Bristol and a Master's degree in Constitutional Law and Administrative Law from Latin American University.
Wonderful, thank you so much. Here's the slides on. Is this the right one? Yeah, if you click on the share at the bottom, on the bottom right, the presentation mode. Yeah, that's one. Yeah, perfect. Thank you so much. So this research was funded by the ILO From Research to Action project. Our report outlines the findings of a systematic evidence review of academic literature that sits at the nexus of both modern slavery and child's rights research. These fields of literature are traditionally separate, and our research shows that meaningful engagement with both of these fields is limited. However, synthesizing these two fields together offers greater collaboration of ideas, a development of theory and practice, the potential to better understand and fulfill children's rights in the context of modern slavery, and hopefully improve efforts to combat modern slavery, including through informing literature, policy, programs, and practice. So the project arose from three key research questions. Firstly, what does children's rights literature say about modern slavery and child labour? How can children's rights literature inform child labour and modern slavery policy and practice? And how can modern slavery literature inform the development and theorising of children's rights? The project highlights gaps in theory and understanding within and across these two fields, and reveals what child rights issues are deemed central to countering modern slavery in the current literature. So firstly, let me share our methodology. So this project was a systematic evidence review of academic literature, published between 2000 and 2022. The evidence review had 5 stages relating to data collection, review, extraction, analysis, and reporting. Stage 2 of the review involved identifying and collecting relevant literature, following a standardized and systematic protocol through both database searches and manual searches. The searches for this study were conducted through the University of Nottingham's NU Search Library database, which also includes access to hundreds of external databases. Searches were conducted using 2 Boolean search strings, including a wide range of terms associated with the topics of modern slavery and children's rights. Manual searches of key children's rights, modern slavery, and human rights journals was also conducted. 7,267 records were initially identified at this stage as being potentially relevant to the review. An initial screening of these records was carried out in stage 2, and here, whilst records were not required to have a deep and substantive consideration of both children's rights and modern slavery, They were instead required to make at least passing reference to both. The majority of the 6,154 records excluded at this stage were omitted because of a lack of relevance to both of these fields, because they were book reviews or editorials, or because they were duplicate results. Stage 3 involved further, more detailed screening of the records, with 345 records making it through and a further 14 records excluded at Stage 4. The reports we are launching today is based on the coding and analysis of records published 2015 onwards. So this was a total of 153 sources. A further 178 sources published from 2000 to 2014 were progressed through to Stage 4, but weren't coded, analysed and reviewed for the study due to resource constraints. I'll now pass over to Pamela, who will give an overview of the evidence discussed in the report.
Okay, what I would like to highlight here in this overview of the evidence over time is that this study shows the temporal trends of the academic literature in the period of 20 years. And as you can see on the graph on the left, there is a gradual and significant increase of the literature that is engaging to some extent to modern slavery and children's rights in the last 10 years, from, as you can see, in the year 2000, almost or less than 20 articles to almost 120 in the year 2021. And of course, this involves the coding of more than 1,000 records. And in the graph on the right, you can see the behavior of the 153 records that were included in the systematic review for full review, and which shows a relatively steady behavior over time with an average of 20 per records per year. And I can show you here, this graph shows the overall interaction of the literature and the records. And you can see this block of the 63 records. This is a block of records that is strongly connecting both fields, modern slavery and children's rights. And the message that possibly we need to get across from this systematic review that is after reviewing all these records, we can see that the literature is more engaged in the field of modern slavery than children's rights. Let me show you the geographic distribution of the research by number of records. From all the records that were included in the systematic review, more than 70% were focused on specific geographies, covering 86 different countries. And I would like to draw your attention now to these gray areas on the map. These are records that had no substantive mentions in the records that were included in the review. And this suggests that the literature is not really addressing this intersection, modern slavery and children's rights in these national geographies. If we see the review through a lens of the regional focus, I need to highlight that this study had a global focus. So we were including records specifically addressing different jurisdictions. But of course, as Naomi possibly will notice later in the presentation, we had a limitation of language because all the records that were included in the review were based in English. And of course, that implies specifically a reason of exclusion of some literature in other regions. But as you can see, this map shows that some regions are receiving significantly more attention from the literature than others. For example, you can see that in Africa, 42% of the records are focused on African countries and the African region, and 29% of the records were linked to the Asia Pacific. And of course, there are some other underrepresented regions, for example, Eastern Europe, where the literature is addressing the intersection just in a few records. And in terms of percentages, you may notice that the Latin American and the Caribbean region and the Western Europe are somehow evenly represented in terms of percentages. But something that's interesting, if we just see beyond these percentages, I would like to highlight the literature in the Latin American and the Caribbean region is addressing mostly the literature and intersection child labor and children's rights. And it's mainly focused on 3 countries, Bolivia, Ecuador, and Peru. Something that we additionally noticed after this review is that there is a high level of focus on specific countries. For example, Ghana is represented in 15 records, and countries such as Sierra Leone, Nigeria, and Uganda are represented in 10 or more records. We additionally identified that 39 countries are referenced only in one country, on one record, sorry. So why I want to show you this in a graph on a map is because if we analyze the literature and the interaction with national geographies, we can clearly see that there is a need for a more geographically diverse research. These are the 13 forms of exploitation and that were identified and covered by the study. We identified these forms of exploitation by inductive coding, so we didn't really have a set of predetermined forms of exploitation. We just went to review the records and identify, okay, what are the forms of exploitations that are being addressed. And let me here highlight the dominant frames across the records. As you can see, child labor is the most prominent form of exploitation or frame that is being addressed across publications, with a strong focus on Africa, Latin America, and Asia, representing almost 53% of the records. So child labor is where the literature is engaging the most, with more meaningful discussions on both modern slavery and children's rights. And the second frame, most frequently mentioned, is child marriage, followed by sexual exploitation. And here I need to highlight that there is a degree of overlap between these two forms of exploitation, mostly because the scholars tend to link child marriage and sexual exploitation, which might explain why the percentages are to some degree similar, and they present also a similar focus, a geographical focus on Africa and the Asia Pacific. And as it was possibly expected, human trafficking and children's rights as well are represented with a considerable portion of records, but with a more diverse geographical focus. And something that I find particularly interesting is that at the first stages of the research, human trafficking was the second most prominent form of exploitation that was discussed in all publications. But when it came to assess what is the connection of these records with children's rights, a large portion of records had to be excluded from the study. It's equally important to highlight where the scholars are engaging comparatively less. After the review, we identified a limited number of records that are discussing specific forms of exploitation: commercial sexual exploitation, online sexual exploitation, domestic servitude, and forced begging, and this last one with a strong focus on Africa. In the case of children in armed conflict, this form of exploitation is sitting somewhere in between. Possibly is not the most prominent form of exploitation that is being addressed across the records, but we notice that the literature in this form of exploitation has developed a lot more detail, a lot more meaningful discussions. In the review, this systematic review identifies these 29 rights that are the most referenced across the records and that are strongly connecting to modern slavery. And as you can see on this graph, the dominant discussions around children's rights and modern slavery are connected to the analysis of specific rights. For example, the right to education, the right to health, the right to development, the notion of the best interest of the child. All these are the most frequent rights referenced across the records. Something I would like to highlight here as well is that during the coding process, we wanted to keep track of the degree of engagement, the degree of analysis of the record when addressing a particular right. So if the record was engaging meaningfully with the right, or if it was just a passing preference. And we believe that knowing this provides an understanding to what degree these rights are commonly analyzed. Well, something that's very interesting is that this study provides a closer examination of how the literature is engaging with the Convention on the Rights of the Child and its optional protocols. When we look at the interaction of the records with the 45 articles of the Convention, there is an emerging pattern that, in the reference of the articles. One is that we find a positive engagement of the literature with the specific legal provisions, that are connected with the views and the voice of the child, and the right to protection from economic exploitation, the best interest of the child, all these dominant rights. But comparatively, the literature is less engaged with legal provisions that are concerned with upholding the rights, for example, of specific groups of children, for example, refugee children, the right of children from minorities and indigenous groups, and the right to family reunification, the right to non-return. So this shows that there are some contexts and these specific needs of these groups of children that are being overlooked by the literature. And well, this is a visual representation of the intersection between all these forms of exploitation that we have identified and the children's rights in the systematic review. And I appreciate that it's difficult to see this on a slide. You can see there are a lot of strands. But you might notice that some of these strands are wider than others. And these give us a sense of where the connections are more frequent. And of course, I need to say that we need to take this with a degree of caution, because this visual representation is based on quantitative coding and frequency count. But the systematic review additionally offers a more qualitative approach, where we're identifying the main debates, the main discussions that the scholars are addressing at each of these intersections. Of course, in most cases, the connection mirrors the dominant frame of modern slavery that is being addressed by the literature. What do I mean by this? In the case of child marriage and child labor, for example, the strands are wider, and they show, of course, a more connection to rights, to different types of rights. And this is because the literature seems to be engaging or paying more attention to these forms of exploitation compared to others, for example, domestic servitude or forced begging. The study additionally identifies some self-evident connections, for example, child marriage and reproductive rights, and child marriage and the right to non-discrimination on the basis of age, sex, and gender. For example, the involvement of children in armed conflict and the right to life. But additionally, we have identified interesting variations. For example, child labor shows a strong connection with the right to participation, and these discussions are involved with recognition of children's movements in Latin America, and trying to raise their voices in international arenas, and the opportunities that these children have to actually get their voices heard in these spaces that are still controlled by adults, and the spaces that work under a predetermined set of rules or parameters. And another interesting example is in the case of children in armed conflict, and it actually shows why it's important not to just see the frequency of this representation, but the qualitative analysis that the systematic review offers, is the case of children in armed conflict and the right to non-discrimination, where numerically might not seem as relevant, but it definitely shows a more meaningful discussion in this intersection during and post-conflict. I think, I would like to conclude my presentation there.
Thank you. So the data revealed 8 key themes discussed in the literature: protection, prevention, participation and voice, paternalism, autonomy, empowerment and agency, duties and obligations, gender inequality, and child activism. The most prominent themes discussed were those of protection and duties and obligation to ensure safeguards are in place and effective. The key discussions in these topics related to concerns regarding inadequate protection of children's rights caused by flaws in the international framework and domestic legislation, and the subsequent absence of enforcement. This lack of enforcement was considered to be caused by weak state institutions that do not have children's rights at the heart of their practice. However, the records also went beyond highlighting the need for legislative protection, showing that changes in the socio-economic environment were also needed to protect children and their rights. Gender gaps in legislative protections were also highlighted as a key issue. Whilst prevention was referred to in almost 75% of records, the data reveals that half of these records only address prevention in passing, suggesting that this theme is overlooked in the literature that sits at this nexus of modern slavery and children's rights. A key element of the children's rights movement is an acknowledgement of children's rights, children as rights holders, social actors, and an emphasis on their right to be heard, their voice and participation. This was reflected in the evidence review, with 56.9% of records referring to participation and voice, and 10% of records substantively engaging with the theme of child activism. This shows a recognition of children as social actors capable of making their own choices and able to engage in policy discussions in these areas. Child activism was particularly prominent in discussions on child labour, and here the literature showed that the child's right to participation was a strong basis for children's activism, with their core focus of their campaign centred on a fight against the stigmatisation and eradication of their work, advocating instead for lower legal ages for work. These records revealed a strong tension between the protectionist, paternalist approaches and children's autonomy and agency when looking at child labour. Children advocated for their right to work, claiming that protectionist approaches comprise age-based discrimination and ignore their social, familial, and cultural needs and backgrounds. Instead, they called for the enforcement of working regulations and the protection offered by working rights, protected in work rather than from work, with minimum wages, limitations on working hours, and time for rest, leisure, and play, amongst others. This perception of children contrasts with the dominant discourse flowing from international institutions. However, it was acknowledged that Article 32 of the Convention on the Rights of the Child takes a balanced approach in not banning child labour entirely. Focusing further on child labour, the coding showed that child labour's strongest association was with the themes of the right to education, the right to health, the right to development, and the best interests of the child, with the strongest connection made with children's education. These records showed that children's work could be both harmful for children's health, education, and development. It was also seen as a possible means of gaining access to and enjoying these same rights, as well as opportunities to exercise their autonomy and self-determination. There's a clear debate in the literature over whether child labour should be automatically viewed as a violation of children's rights. Conversely, concern was raised in a few records over the existence of legal loopholes regarding domestic labour and children's work with family members. However, this area of research revealed itself to be in need of further examination. It's noteworthy that the records related to child labour included a significant proportion of primary empirical studies that engaged directly with working children, families, and local communities. Our report also draws together policy recommendations highlighted throughout the literature itself that we studied. On this, the report draws attention to 12 areas of policy recommendations, as shown on this slide. The main recommendations focus on issues relating to legislative reform, enforcement and harmonisation, collaborative governance, and the reconciliation with context, tradition, religion, and cultural practices. Other key areas of policy recommendation related to prevention and protection, children's participation, voice and empowerment, and other specific children's rights. The record showed a clear criticism of inadequate regulatory frameworks with gaps or loopholes related to child trafficking, child marriage, child labour, inter-country adoptions, and a need to reform the juvenile justice system for children involved in conflict. They also point to a need for new regulation in new areas, such as child trafficking in the football industry, children's digital protection, and prohibition of goods manufactured involving child labour. Beyond the need to reform regulation, implementation and enforceability was emphasised as a key issue, alongside a need to resolve tensions and compatibility of international, regional, domestic and local frameworks and systems. The literature pointed to a need for standardised and harmonised terminology to allow for alignment amongst stakeholders and a clarity of concepts. However, it also showed a need to acknowledge and account for local context, traditions, religions, and cultures. Criticism was also raised over blanket policies that may have negative consequences for the realisation of children's rights. This is a clear tension that poses a challenge for policy reform. The need for both conceptual clarity and a reconciliation with local context is important for both addressing modern slavery and protecting children's rights more broadly. The research called for impact assessments with well-defined indicators to be conducted prior to legislative and policy reform. Addressing the root causes of both modern slavery and breaches of children's rights was a key issue addressed across the records. Although explicit recommendations were raised in 16 records, poverty, social exclusion, gender equality, unemployment, and the lack of education were identified as factors that foster the exploitation of children. Measures that don't address these structural constraints were therefore considered to be insufficient to face the challenge of modern slavery and the protection of children's rights. 16 records specifically presented education as a mechanism in the fight against exploitative practices and as a tool for empowering children, with strong connections made to child marriage and child labour, and suggested benefits in relation to prevention and empowerment. To conclude, children's rights were generally assessed to operate as a positive tool or a framework for addressing modern slavery, delivering overall benefits for children at risk of, experiencing, or recovering from modern slavery experiences. In total, 124 records, over 80%, clearly presented children's rights as a positive tool. While perspectives on the value of children's rights as a framework were generally positive, 3 records, just 2%, considered children's rights as a negative tool. These highlighted the cultural specificities of conceptions of childhood, suggesting that the children's rights framework is not always well suited in different contexts, and that it can fail to address the fundamental issues and root causes of modern slavery. A further 26 records had mixed perspectives on the value of children's rights, recognising both strengths and shortcomings of the child rights framework. A key object of this project was to explore how these two fields of modern slavery and children's rights interacted with each other. With less than 350 records making it to stage 4 of this project out of over 7,000, due largely to a lack of meaningful engagement in the literature with both fields, it's clear that there is a need for these fields to communicate with each other more substantively in order to ensure that research relating to modern slavery of children addresses and is informed by children's rights. A child's rights compliant approach to research relating to modern slavery of children would also require involvement of children in research as participants or as co-researchers. The modern slavery of children is a child's rights issue. Therefore, research on this topic should not be removed from or separate from discussion of children's rights. This review has shown that where these two fields of modern slavery and children's rights have intersected with meaningful discussion of both topics, it's of considerable value and offers critical insights. Yet this is not currently common practice in academic literature. Such engagement would ensure that modern slavery legislation, policies, programs, and practices are informed by the child's rights framework. Likewise, children's rights theory and practice would benefit from a greater understanding of the context of modern slavery, informing advocacy, implementation, and the development of children's rights itself. This report and today's launch aims to initiate a deeper interaction with these two fields across the literature and practice. Thank you very much.
Thank you very much, Naomi. Thank you very much, Pamela. Our next distinguished speaker is Urmila Bula, the former UN Special Rapporteur on Contemporary Forms of Slavery. She's a former judge of the Labour Court in South Africa and chief legal drafter of South Africa's Employment Equity Act. She's a former executive director of International Women's Rights Action Watch, Asia Pacific, and she's currently a research fellow in global anti-slavery policy at the University of Nottingham's Rights Lab and a visiting professor at University College London. It's great to have you here, Urmila.
Thank you, Maya. It's good to be here. Thank you, everyone, for being present. And I think I want to start off by congratulating Naomi and Pamela and also Katerina Schwartz of the Rights Lab on this excellent report. A really commendable piece of research, and it's been fascinating to listen to your conclusions and your findings today. I think I just have a couple of things to add really on the issues related to the extent to which child rights protection is adequately encompassed within policy approaches, specifically international policy approaches to addressing modern forms of slavery. In my report to the General Assembly on the issue of child slavery in 2019, I made the point that there needs to be greater definitional clarity and also more uniformity and standardization in understanding child slavery. And it's quite interesting to pick up that your findings cite only a minimum number of records, about 12, I think, which refer to reconceptualization. So I think that sort of creates quite an important area of focus. We really have, if we talk about definitional clarity, we really have a number of instruments that come together to create a comprehensive scheme of protection. We have literally the Antislavery Convention of 1926, which makes no reference to children and deals with children in the context of adults subjected to slavery and the slave trade. The 1956 Supplementary Convention adds to that definition, but does make specific reference to children in the context of prohibiting as what is referred to as a slavery-like practice, the sale or the transfer of a child by a parent or guardian for exploitation or for labor. So we see the first reference there to a specific issue related to children. And then, of course, we have the Child Rights Convention, which does provide very specific, broad protection. So, as you've mentioned, there's no prohibition or ban on child labor that is required by states, but there's a reference to economic exploitation and hazardous work of children. In the same line, there's protection of children against sexual exploitation and abuse, abduction, sale of children, and trafficking, and any other exploitation which is prejudicial to any aspects of a child's well-being and welfare. In addition, we have the Palermo Protocol, and the definition of exploitation in the protocol again comes full circle with reference to exploitation being linked to slavery and also obviously happening in the context of trafficking. And then what complements this entire scheme is the International Labour Organization conventions, where we have the Forced Labour Convention and Protocol of 29 and Convention 105, which again make no specific reference to children. But complementing that, we have the Minimum Working Age Convention, Convention 138, and Convention 182, which really is the first conglomerate expression of child slavery in the form of child slavery being subsumed or being considered a worst form of child labor. So we really have, we clearly don't have a common definition of modern slavery or of child slavery. In any event, I think if we talk about child slavery, probably we need to be very conscious about stigmatization. But what we really have is a framework that consists of a conglomerate of issues related to child rights being encompassed within that framework. And this results in a number of difficulties, I think possibly fragmented approaches at the national level, where there are a number of gaps. Your research already alludes to the gaps in addressing domestic servitude, domestic labor of children, and to some extent children in armed conflict. But it can also lead to a failure to address the structural and systemic causes, the root causes of child exploitation. So we may find gaps inherent in the way in which those laws are interpreted. So for instance, we find in the first European Court of Human Rights decision, Ciliadin versus France, which looked at a child from Togo who was 15 years old, sent to work with a family in France. And she was subjected to domestic servitude, worked for two families. And the court then grappled with that notion of the classical form of slavery envisaged in the 1926 convention, which is the status of condition of a person over whom the powers relating to the right of ownership are exercised. And the court found that there wasn't slavery in that classical sense, but she was subjected to domestic servitude. But of course, there was no definition of domestic servitude, and it wasn't clear what the state's positive obligations were in relation to protecting a child from domestic servitude. So the court started exploring those gaps in protection that existed and found that there were specific obligations on the part of France to address that issue, because it was pre-Palermo, so it couldn't quite put it under trafficking, and it didn't deal with it specifically as forced labor because it looked at, although it did say there was no direct menace or threat of a penalty because she was mobile, the child was able to travel from one household to another and had some mobility, so there was no ownership in the traditional sense or forced labor in the traditional sense, but it did say there were elements of forced labor present, but it found servitude to be present. So it really links to the issue that's been raised, I think, which is in your research as one key gap, which is how to address child domestic servitude. A lot of my work has involved in traveling for the mandate, has involved going to West Africa, and my last visit to Togo focused specifically on child domestic servitude and looking at the situation that arises specifically where the point that has been made about cultural relativism and the relevance of cultural issues arise. So, we have a situation where, for instance, there's a system of concierge where it's really a notion of community support, but it involves a child being sent from one family to another for that family to provide access to education and the child providing domestic services in exchange. But that is, in most instances, involved into a situation where there's the opportunity for exploitation of the child. And there are gaps in national policy in terms of how to address the issue. And so it raises the question of to what extent international policy should be a lot clearer in terms of specifically, clarifying what should be national policy. And at the time of my visit in 2019, there was no clear child action plan, a national action plan on addressing child labor, including domestic servitude, was only developed in 2020. So we saw a huge gap, and the way in which that was addressed, for instance, in other contexts of one of my other country visits was to Paraguay, where we had the issue of criadazgo, which is also a similar arrangement. And there, the way in which it was dealt with to a large extent is to define criadazgo because it became so exploitative. And it resulted in a case before the Inter-American Court of Human Rights where there was an extreme case of violence against a child. And so that was dealt with as a trafficking issue, as an internal trafficking issue, because it was mostly children from the Chaco region and indigenous community children who were sent to urban areas to perform domestic servitude. So we see that in practice, there really is this huge gap in translating the protection and defining clearly the extent of child domestic servitude. The other issue that's raised is, so for instance, the issue of the worst forms of child labor and the way in which they manifest in global supply chains. That is a huge gap because, again, we have no clear binding standards. The European Union's in the European Commission is still developing this legislation of mandatory human rights due diligence is still before Parliament, so it remains to be seen what final form it will take. So the extent to which businesses have to investigate, prevent, protect children, ensure remediation under the UN guiding principles as a voluntary approach were in regard to protecting children in global supply chains, like the many girls who work in the garment industry, for instance, in Tamil Nadu, Sri Lanka, Bangladesh, Vietnam, and Cambodia. I mean, those are still issues that, where there is a huge gap, although, of course, the European countries developing their own national legislation to that extent. So again, we find a lack of very clear international binding norms, which creates a gap in policy and also a failure to hold corporates and multinational business enterprises accountable for violating the human rights of children. And then the other context I wanted to mention, which has also come up in your research, is the issue of child marriage, where there's still no clear prohibition in international law. We have the CEDAW, the Committee for the Elimination of Discrimination Against Women, which recommends the age of 18 as a prescribed minimum that national governments should set. But there's divergence, which, as your report quite aptly points out, there are countries which have much lower ages of child marriage. And what was quite interesting was, in terms of those records that you mentioned, the number of the least number of records relating to domestic servitude, child marriage, and also children in armed conflict. So, that clearly picks up where the gaps exist. And one of the key gaps, again, is it's an issue that came to the forefront in a joint mission that my mandate conducted together with the mandate on the sale of children, and the mandate on the right to adequate standards of health, Danius Piros. We conducted a visit to Nigeria, which was the first foreign visit allowed in Maiduguri, in the northeastern state of Borno, during the Boko Haram insurgency. And what we did was really to try and develop a child rights-based approach to understanding the issue of recruitment of child soldiers, of abduction of girls, like the Chibok girls, the 276 girls who were first abducted by Boko Haram, the issue of servile marriage of forced marriage of young girls that resulted in many of them having babies, and wide-ranging stigmatization, exclusion from the community, and really references to those children as being snakes that should never be protected in the community. So a whole range of issues that arise in relation to forced marriage by non-state armed actors in the case of conflict. So which sort of really extends that whole issue of, addressing children in armed conflict and child slavery in that context, and how international policy deals with it. And then perhaps just 2 final points, if I may, is the issue of children in street situations. So the issue of forced begging, which also came up in your research as one of the areas where, the least number of records, which, is again reflects the kind of lack of clear policy in terms of understanding whether forced begging is prohibited as a form of modern slavery. So, for instance, we find it's in the Australian legislation, modern slavery legislation, there's a reference to forced begging. Some states, for instance, Belgium, have recognized that forcing someone to beg is a crime, but where children beg with their parents, that's not a crime. So, for instance, they found in my country mission to Belgium, I found a lot of children, families from the Roma community begging. But it really obscures the question of who is the exploiter. Is it, it also applies to the situation of forced labor or the worst forms of child labor, because is it the parent being exploited by a third party and the child being subsumed under the parent's exploitation? Or is it a case of the parent actually, as we find in a lot of situations relating to online sexual exploitation of children in the Philippines, where the parents are the ones forced by poverty or dire economic situation to really put their children in situations of exploitation. So, the perpetrator of slavery is not that clear cut, and the agency of a child is affected by the guardianship and the ownership at least of the parent. So, it related to the question in Niger, of children who are supposed to be in Islamic schools and receiving an education, but the marabout, the Islamic teacher, sends them out to beg, they're forced to beg. And that becomes a key question relating not only to how one protects those children, but prevention and education as a key form of prevention. And education clearly mentioned in the CRC, but to a large extent is missing from other legal provisions. So we see a reference to it in recommendation 203, which is a recommendation to the forced labor protocol, but not in the protocol, and particularly education in the context of the child. And recommendation 203 specifically refers to girl children. So, it really requires looking not so much at the action that results in enslavement, which is really what modern slavery tries to deal with. And often that's met with a criminal justice response. So like the act of recruiting a child soldier, but the context in which that happens and the issue of prevention, the structural and systemic issues which actually prevent the child's rights from being realized. So the issues of, how one reintegrates, say, the young girls abducted by Boko Haram and forced to bear babies and forced to marry Boko Haram soldiers, how one reintegrates or at least creates a sense of rehabilitation of those young children. So there are a number of issues that arise, and clearly your report has picked up on, the key gaps that exist in the research and that exist in policy, and reinforces the point about addressing root causes, structural, systemic issues, but also integrating the two areas of research and practice, and also integrating two areas of policy to make sure that protection of child's rights and the best interests of the child and the needs of the child are paramount and are integrated in a coherent and comprehensive manner into modern slavery response. So I'll leave it there. Thank you so much.
Before we move to our final speaker, I think we have some people waiting to join online. Is it possible to admit? Or okay, so our final speaker from the panel is Dr. Elizabeth Faulkner. She's a lecturer in law at Keele University. Her interests are in international child law, human rights, crime, legal history, and human trafficking, slavery, children's rights, exploitation, and sexual violence. So very much to the core of our discussion today. And her book, The Trafficking of Children, International Law, Modern Slavery, and the Anti-Trafficking Machine, was just published by Palgrave Macmillan. Congratulations. And her edited collection, Modern Slavery in Global Context, Human Rights, Law and Society, should be published later in the year in Bristol University Press. Her research seeks to centralize the neglected histories of child trafficking and the entanglements of children's rights and colonialism. Let's hear from Elizabeth. Thank you.
That sounds like quite an impressive introduction. Thank you, Maya.
Quite an impressive scholar.
I think that from listening to the conversations today, my own positions in and around children's rights and how children's rights are often excluded from the main conversations around human rights. We exist on the periphery, children's rights scholars, and there's a feeling of separation between the broader international human rights law research that's conducted with children's rights on the periphery. And I think it's quite interesting when we talk about modern slavery, because modern slavery as a construct isn't something that's universally accepted outside of the UK. It tends to be a term that is predominantly used here in the UK, with Australia following suit with their Modern Slavery Act in 2018. And when we talk about this disconnect between children's rights and modern slavery, that's something that is covered specifically within the book that you've just kindly mentioned. And one of my frustrations around children's rights is that children's rights are often perceived as this global benchmark or blueprint for the rights of the world's children. But what's often neglected is that human rights and international law more broadly are actually a manifestation of more colonial logic and imperialism imposing children's rights, framed from a Western perception that children are more inherently protected, or traditionally children are within the family unit and they have a preconceived ideal around children, particularly around migration, trafficking and mobility, that children are vulnerable and therefore they should not migrate. And that links back to the League of Nations archives research that I've conducted in that perception that children should not migrate. And one thing I found interesting from hearing about the report today was the focus around domestic servitude and domestic services. I think the recent revelations by Mo Farah have been really interesting in terms of him, he being trafficked here as a child to be exploited for domestic servitude, and the fact that the Home Office had to come forward and specifically state they wouldn't prosecute him is quite interesting, or quite telling and worrying about the current state of affairs for children's rights here in the UK, particularly with the progression from the Modern Slavery Act to Nationality and Borders Act to the horrifying illegal immigration bill, which is currently under discussion at the moment, which places a whole lot of issues particularly around children's rights and the deprivation and removal of rights that each and every child should be afforded to. So for me, what I find interesting there is around the domestic services issues that you mentioned, because some of the things I found in the archival research and looking through the League of Nations responses to trafficking was that they were focused predominantly on children that were transported or trafficked for immoral purposes, or that's sexual exploitation, prostitution, which are the words that we tend to use today, although we've moved away from prostitution as proven by the renewal of the HRC, renewal of the mandate for the Special Rapporteur. They've removed child pornography and child prostitution from the title, and I think that's a wonderful move, because language is important. But in terms of domestic services, Cyprus, for example, in the 1920s, frequently reported a practice where younger, impoverished Cypriot families sent off their daughters to richer families where they served as indentured servants. But because there was no element of immoral exploitation or exploitation for sexual gain or commercial sexual exploitation, it was deemed as a lesser harm perpetrated against those individuals. And I think that idea of what's a lesser harm and what's a greater harm is something that is inherent in the current international framework and the policy responses, particularly when we look at the worst forms of child labour. Or if you look at the rankings and the way that there's a hierarchy of harm created, and that this idea that the sexual abuse of a child or sexual exploitation is the worst of the worst offence that can be perpetrated against a child. But what that often, not often neglects from, but what that identifies is that commercial sexual exploitation is much worse than a non-commercial sexual exploitation of a child, or that the trafficking of a child means that the exploitation that child is exposed to in a country that's not their own is worse than exploitation that might be faced within their own country. So it creates these differential layers of protection, and I think that links in with the powerful protectionist discourse that you were talking about in and around the report, in that children are often perceived as a vulnerable, inherent in need category that need protecting. But that also endorses the issues of rescue narratives, in that if we see children working in and around agricultural industries, for example, there was a research project at the University of Liverpool, chocolate. It was called Chocolate and something. It was headed by Alex Welch. Yeah, you know the one I mean. Yeah, and that I looked at the idea that if you go in and rescue children that are actively engaged in agriculture and remove them, then what happens when there's not that framework or that Western ideal that you can remove the children from the fields and you can place them into education, and therefore their rights are being secured and they're going to have a better life moving forward. And I think that's where this conflict between children's rights and modern slavery comes to the fore, in that modern slavery, the legislative reforms anyway, around the issue, strip away the agency of children in a way that clashes with the Convention on the Rights of the Child. I think when you were mentioning about the literature, when people were talking about children's rights in a negative way, I think that might have been myself that was critiquing the children's rights framework. But I think it's a really interesting conversation to have, and it might not be a popular perception, but that doesn't necessarily mean that we shouldn't engage with criticisms of children's rights as inherently problematic in the way that they approach childhood, labour and protective characteristics of children. And I feel I've gone off on a tangent, but I don't want to go off any further.
Okay. Thank you very much. Thank you very much for all of our panelists. If it's okay, before we open the floor to questions, I see we already have one in the chat and we perhaps have more in the room. I would like to refer one or two questions to the panel, drawing on some of the things Elizabeth just mentioned and some of the things Urmila mentioned earlier. And one perhaps following directly from this point is, to what extent do you think, and I think we'll start with Naomi and Pamela and let you respond to this question, and perhaps to Elizabeth's final point, to what extent do you think that the children's rights framework could be argued to pull in one single direction that could be applied as is in the intersection of children's rights and modern slavery?
Yeah. So I think a common framing of children's rights at the moment, at least, is that it is this Western ideal that's imposed on the world, and I don't think that fully reflects the drafting process of the convention. And I think that I actually am writing a paper at the moment that suggests that perspective actually serves to further infantilize the global South by saying that their involvement wasn't important or wasn't big enough. I think this dominant framing of children's rights in this protectionist way, as we showed through the report, and this tension with agency and empowerment, I think actually in the modern slavery area shows a misunderstanding or a lack of full engagement with the child rights framework and what it actually offers. Elizabeth obviously pointed to rescue processes and how actually they can be incredibly damaging, but they tick the box of we've got children in education. Well, actually, a full understanding of the child rights framework that fully understood and implemented and considered their right to health, so mental health, physical health, and all of these other issues, including agency and voice participation, would mean that we can remove children from exploitative, harmful contexts in a child rights compliant way that isn't also further damaging. That requires greater resources. It requires greater engagement across these two fields, which is why we've written this report and why we've done this research to try and instigate this conversation. But I think if done properly, it works. I think having a poorly kind of a poor understanding of children's rights by not engaging with it in insufficient depth is where these problems arise.
Thank you. And Pamela, would you like to add anything?
Yes, something that I forgot to mention while I was presenting is that from all the articles that we have reviewed across the systematic review, there is 88% of the records that specifically are referencing to legal provisions of the CRC. But from all these articles, there's a big percentage of articles that don't really are addressing the legal provisions of the CRC. And this can be seen as possibly negatively if we are supporting the view of that that it's important to raise awareness of the understanding of how important is the CRC tool for addressing modern slavery. But this will be taking a stance on how positive is actually the children's rights for the general discourse. And I believe that something that has mentioned Naomi is that there is still some tension regarding how actually universal is and applicable is the CRC in a specific cultural context. And on top of this, there is additional specific issues that are identified by the literature in terms of what is actually included in the CRC. For example, the lack of a specific provision of child labor, establishing a minimum age for marriage, or the contradiction between Article 1 and Article 38 in terms of the recruitment and the difference of what is a child, but then how we, in the same convention, we leave a range of children above 15 years old unprotected from these recruitment practices. And the definition itself of what is a child, and the treatment of all children are the same, and are affected in the same way by the forms of exploitation, and not making these differences if it's a child that's over 15 or under 15. So I feel that there is still a lot of unresolved issues. This systematic review is trying to see what is the sense or what are the main discussions in the literature. And I believe that it's important to explore a little bit further what are these negative connotations of the children's rights, and if it's actually the solution for addressing modern slavery more in a more personal view.
Thank you. Humira, would you like to comment on this question?
I mean, I think that there really needs to be a balancing of issues. So the balancing the autonomy, the agency of a child versus the element of, because there are rescue initiatives that have succeeded. So, Bachchan Bachao Andolan and Global March Against Child Labour, I think that in that specific context, the rescuing children from debt bondage and intergenerational debt in brick kilns, for instance, to which their parents are subjected. But I mean, I agree with the point being made is that, so what next? And I think that it's critical to get the balance right, and I'm not sure, whether that's even possible given the kinds of complexity of issues that children are exposed to.
Thank you. Would you like to comment on that?
Yeah, I think the position that the Global South's been infantilized, because it doesn't really reflect their involvement, is something that I disagree with. I think that the Global South were involved in the negotiations to an extent, but if you look at the way that the Convention on the Rights of the Child is celebrated as the most widely ratified human rights treaty, but there was an understanding, particularly on the African continent, that the adherence to the Convention on the Rights of the Child would be linked with aid. So there's lots of different conversations to be had there, and in and around the idea of rescue initiatives. I appreciate some have been successful, but it all builds in and feeds into this idea of how we've got an ideal construction of who is a child, but also who is a deserving victim and who is not a deserving victim. And that is something that really plays out, particularly in the UK context when we talk about Asian grooming gangs. We look at class, we look at gender, we look at race, and we look at who are those ideal victims that deserve protection, particularly if we're looking at Rotherham, for example. Those girls weren't the ideal victims. You have the VCLN case, which went up to the European Court of Human Rights, where you had trafficked individuals from Vietnam who'd been used for cannabis cultivation. It was so there is another issue there, in that we have preconceived ideals around who is a child, what their rights are, and how they should be protected. But those levels of rights protection are unequally provided for, and we need to start addressing undercurrent issues that are around race and the racialised coding that fits in with modern slavery, particularly as it manifests itself here in the UK. And you can see that in relation to children, modern slavery being previously framed as a safeguarding issue in October 2022, it was moved over to immigration, to the immigration portfolio. And I think that shift is quite significant and problematic, and it also creates a level of difficulty when we're trying to talk about children's rights in relation to modern slavery, because modern slavery isn't about children's rights. Modern slavery is about criminal justice and the state being able to prosecute. It's not about children's rights, and that's really clear through the illegal immigration bill.
Thank you. Sorry. It was going to be like that. My second question was going to come exactly to this point of the intersection. One of the challenges that seems to me that you're addressing in this report is taking a discourse that was developed, broadly speaking, within a human rights framework, and how it intersects with discourse that was developed both internationally and domestically, primarily as the law enforcement criminal law intervention. And I want to stay with this question Elizabeth raised for a bit of, what does it mean for children's rights approach to modern slavery or trafficking, the relationship between the human rights and the criminal law? If this is something that you could comment on, whether based on the literature or your conclusion following working on the report. And this links directly to one of the things that Urmila pointed out about the differences between the criminal law enforcement interventions and addressing structural issues that seems to be a shortcoming in, again, domestic and international order.
Yes. I think this is a really difficult topic, hence why we're here. And actually, it's an interesting thing raising this kind of, it's not a human rights issue, it's a criminal issue. My LLM dissertation I wrote on the definition of modern slavery, one of the feedback I had was you haven't engaged with criminal law enough. It's a criminal issue, not a human rights issue. And human rights professor who read it disagreed and said, actually, no, this is a human rights issue as well as a criminal law issue. And I think that that's an inherent tension that we're going to have to deal with across the way, because it is both issues. Children's human rights are implicated pre, during, and post modern slavery. But it is, yes, a criminal issue. And I think how we relate to this, I think it's better understanding and better application of the children's rights framework in a way that means that it does inform the criminal justice system, that it does inform the immigration system, and I think actually going about this in an intentional way that makes sure that we don't treat certain groups of children worse than others, and in a way that means that we have a full understanding and a full application of the child's rights framework within this criminal context, I think is possible. But again, it's not going to be easy. It's going to take time. I don't see them as incompatible.
Just
After Pamela?
Yeah, sure.
Just a brief comment. It's really brief.
But you can comment on both then.
I'm not sure if the question is modern slavery is a human rights issue and what do we think personally, or how it's treated in the literature. And if we look at the systematic review on how it's being treated across the records, I think that just by taking a look at all the large number of records that have been excluded on the basis that these records have to be addressing both modern slavery and children's rights, we can conclude that the literature not always and most predominantly doesn't treat modern slavery as a human right. And that's the reason why we, from 7,000 articles, we only have concluded and included 300 articles. Yeah, and I think that's is an important evidence that we need to take into account. But if we take the stance of modern slavery is a human rights issue, we need to recognize that addressing modern slavery and fulfilling human rights doesn't really require a criminal approach. And this is something that is widely criticized across the records, and this narrow focus of just addressing criminal approaches. And we can see a very clear tension in the literature between the prevention and the protection side. And the predominant discussions in the literature is mainly protection. What is the persecution? But to fulfill a right, we cannot only see, we need to persecute this criminal offense, and because the right of the child doesn't end in persecution and in a sanction of the perpetrator. Because to fulfill a right, we need to look at the post phases after the child has been subjected to a form of exploitation, and how we're going to restore the life of that child. And that requires, of course, a lot wider focus.
Thank you. No, you could.
It's only a really minor point. It was just around children's rights. It came up in a conference at the SLSE. Professor Lundy, her participation model, she said that there's been new NRM training that's been developed where her participation, the Lundy model, has been incorporated within the NRM. So there's like an explicit recent move in terms of integrating, or how we can integrate children's voice and participation within the context of modern slavery responses. Lundy model.
Thank you. And Romina, would you like to comment on?
I mean, I think there's, I agree basically with what everyone has said. There's a really interesting example of a claimant from Niger, who Hadija Djoumani Korao, who brought a claim before the ECOWAS Court of Justice. She was sold as a child. She was born into descent-based slavery, into a slave caste in Niger, sold as a 14-year-old child, and was not able to achieve justice within the Niger national court system because slavery wasn't prohibited, or at least this Wahaya practice of a child being taken as a fifth wife into a household and exploited in that situation was not recognized under the law. So she succeeded in the ECOWAS Court of Justice, but her husband then brought a claim, even though she wasn't fully properly married, brought a claim under the criminal law for bigamy against her, which was only resolved by the Court of Appeals in Niger in 2019. So we have this sort of litigation that spans over, a decade, almost 2 decades, but it involves a situation of her human rights violation. It's a development issue because there are clear issues of poverty, child marriage issues, family rights issues, what is a marriage, what is a legitimate marriage. So there's the criminal justice framework because her husband was not penalized, he was not charged. And the bigamy charge, which is her crime of bigamy, was only resolved in 2019. And so, there are a whole range of family law, development, poverty issues. So it's human rights, it's humanitarian law, if we look at child soldiers, and a family law in relation to child marriage. But the big gap is labor inspections, which obviously in the case of domestic servitude don't apply. Labor inspectors don't go into private homes. So enforcing the labor law and identifying even the worst forms of child labor, because although countries would have ratified the worst forms of child labor, Convention 1 and 2, they have not necessarily have developed a list of hazardous labor. So it's not really something that the labor administration can administer. So it's a labor rights issue. It's also a criminal justice issue. So child rights really spans across that entire spectrum of social, economic, political issues. And it really does need a kind of whole of society, a whole lifestyle recycle approach. And really, I don't like to use the term mainstreaming, but I can't think of another term, because it's almost mainstreaming is like it's on the periphery. So how do you integrate it? But you integrate it within a system that remains the same when you really need to dismantle many aspects of the system. So, but it really needs a coherent identification in all those areas of law and society in relation to child rights and the best interests of the child. And of course, we have the development focus now with the 2030 SDGs and Target 8.7, which looks at, a universal commitment to end child labor by 2025. And with that, very easily done. We'll achieve it by next year, I think.
Thank you. I think it's a really interesting point. It's not, if I hear you right, of your child-based approach as sort of the big umbrella objective, and every other areas of law as different ways of getting there through different areas. I don't know if this is a helpful way of thinking about this question. We have some questions in the chat that I cannot read from here, and we'll